Okay, I'm going to read basically over what I just went over quietly in the competence, malpractice, and civil liability section, all the way through to different roles of a lawyer. And then I'm going to read everything from that point until the end of this recording. I'm going to read the definition of competence and diligence. Competence, when representing a client, a lawyer must act competently, for example, with the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation. Coming from Model Rule 1.1, the first number in letter A about competence is legal knowledge and skill, and the factors in determining requisite skill. So Romanet 1 is the complexity and specialized nature of the matter. 2, the lawyer's general experience. 3, the lawyer's training experience in the field in question. 4, the preparation and study the lawyer is able to give the matter. And 5, whether it is feasible to refer the matter to or associate or consult with a lawyer of established competence in the field. B, under the section of legal knowledge and skill, is becoming competent through preparation. And C, emergency situations. Number 2 within competence is thoroughness and preparation. 3, retaining other lawyers to assist in the matter. I saw 2 Romanets in that section. The lawyer must reasonably believe that the services of the outside lawyers will contribute to the competent and ethical representation of the client. And 2, should ordinarily obtain the client's informed consent. This is looking to come from 1.1 comment 6. Maintaining competence, technology, and continuing legal education is the last part under competence. Then diligence, like I said, is a requirement under 1.3. A lawyer must act with reasonable diligence and promptness. Defining that is that a lawyer should pursue a matter on a client's behalf despite opposition, obstacles, and personal inconvenience that may take whatever lawful and ethical measures are required to vindicate the client's cause. The lawyer should act with dedication and commitment to the client's interests and with zeal and advocacy on the client's behalf. That's in comment 1 of 1.3 of the model rule. Now, A, under the definition, is diligence does not require incivility. And then the workload is B, which comes under the definition. 2, under diligence, is promptness. 3, under diligence, is completion of the matter. 4, under competence, existence of lawyer-client relationship. And 5, solo practitioners duty to plan for death and disability, naming someone that can notify the clients of the circumstances so that it doesn't have to be done by court order. Then we move to C, which is beyond competence and diligence, which is just stating that a single violation is sufficient to impose disciplinary actions. It doesn't require a pattern. D is malpractice and other civil liability and discusses how they are different. In 1, the relationship between disciplinary matters and malpractice actions. 2, ethics violation as evidence of legal malpractice. Contrary to the name, a lawyer's breach of an ethics rule does not automatically or presumptively mean that the lawyer has committed malpractice, but it is relevant evidence. I think it's really good stuff here to discuss in Romanet 1 how malpractice and disciplinary actions are different. So in a malpractice action, the forum is civil court, not a disciplinary tribunal. 2, in a malpractice action, the attorney's adversary is an injured plaintiff, not the state bar. And 3, the purpose of a malpractice action is to compensate the injured plaintiff, not to punish the attorney, and not to protect the public from future wrongdoing. So the forum and the adversary and the purpose. So theories of malpractice liability. This is really good to know. So there's intentional towards breach of fiduciary duties and breach of contract and negligence. Negligence gets broken down further, but and it is the most popular. But intentional torts could be fraud, misrepresentation, malicious prosecution, abuse of process, or misuse of funds. Breach of fiduciary duties is involving loyalty, confidentiality, and honest dealing. A breach of contract can be express or implied warranties, such as implied promise by the attorney to use ordinary skill and care to protect the client's interests. Negligence is the same as torts, requiring a duty of due care, breach of that duty, legal causation, and damages, which we go over in one. Duty of care to the clients, to prospective clients and third parties, which is your third party Benny, and also the third party service provider is one in where the attorney invited the third party to rely on her opinion or legal services. So that's relevant. And the standard of care is the last part under the duty of care section. And that would be competence and diligence normally exercised by attorneys in similar circumstances is the standard of care under duty of care. So next is the breach of the duty of the care. And A is errors of judgment, which key terminology is well informed and reasonably made. Errors are not ones that you'd view as a breach. And B, knowledge of law, which the expectation is to know the ordinary settled rules of law known to practitioners of ordinary competence and diligence. C, calling on a specialist. If a reasonably prudent lawyer would have, then you should have. Legal causation is the but for the defendant's negligence, the and furthermore that it is fair to hold the defendant liable for the unexpected injuries or for expected injuries that happen in unexpected ways. And lastly is damages. 4 is civil liability other than malpractice. I just have a breach of warranty and lawyer's promise again. So that's all I checked. As really important in that section. 5, liability for negligence of others. So partners are jointly and severally liable, and respondent superior applies malpractice insurance and settling malpractice claims. So malpractice insurance it stands alone, right? But settling malpractice claims is permitted only if the lawyer first advises the client in writing to seek the advice of an independent lawyer about the settlement, and the lawyer gives the client a reasonable chance to obtain such advice. But it would not be permissible to ask the client to prospectively waive or limit malpractice liability in, like, say, a standard form. There's this thing called a limited liability entity, which would not involve partners. That seems kind of like a sole practitioner, and it's like it's treated the same. Okay, so may reasonably limit scope of representation. I don't know. Are these mitigation strategies? Because that's letter B. Letter A. Okay, so prospective waiver on limit to of malpractice liability. Well, I don't know why they bundled may reasonably limit scope of representation with the whole limited liability entity, and then the next C may arbitrate legal malpractice claims. So there's all bundled together. 9, reimbursement of the client does not exonerate a attorney from disciplinary action for a wrong. So there's a next section after this, I believe, yes, which is litigation and other forms of advocacy. So A is the meritorious claims and contentions only, and 1, discipline for asserting frivolous position, which says what that isn't, which I think is important. It does talk about Federal Rules of Civil Procedure litigation actions and Rule 11 for frivolous pleadings and motions. But then I think more importantly, what is not frivolous is to assert a position without fully substantiating all the facts. Is not frivolous to assert a position knowing that vital evidence can be uncovered only through discovery proceedings, and it is not frivolous to assert a position even though the lawyer believes that the position will not ultimately prevail. And defending in criminal proceedings is number 2 under this section. So it's really not saying much, but saying that the prosecutor has to prove every element of the crime. So I guess that means that if you don't have a valid defense, you don't want to bring a frivolous one, but I guess the countervailing force is that the prosecutor has to prove all the elements of the crime beyond a reasonable doubt. So I guess you could just be silent if you have a bad case. But B is the duty to expedite litigation. 1, reasonable efforts to expedite litigation. 2, interests of the client. I found this interesting section. C is duty of candor to the tribunal. 1, candor about applicable law. And so this part's really going to come up. It's important that false statements of the law have to basically be corrected, or an attorney can be subjected to discipline. Failing to disclose controlling authority, even if the opposing counsel has failed to identify it, can run an attorney Rule 11 sanctions. And candor about facts of the case can be subject to discipline if you fail to correctly characterize a fact and do not correct that when you become knowledgeable of the inaccuracy. There's some, I guess, examples within the definition. 3rd, under the section of duty of candor to the tribunal, after the applicable law and the facts of the case comes no obligation to volunteer harmful facts. The exception is during ex parte proceedings. You do have to inform the tribunal of all material facts just so that they can make an informed decision. And 4th, using false evidence. This is the most thorny issue, apparently, is when a lawyer may refuse to offer evidence that she reasonably believes is false, except for a criminal defendant's testimony on his own behalf. And there's a section under 4A, discovery of falsity after evidence has been offered. What you do first, the lawyer must be confidently with her client, urging the client's cooperation in withdrawing or correcting the false evidence. And second, if the client will not cooperate, the lawyer should consider asking the court's permission to withdraw. And I guess 3rd, which doesn't say 3rd, but I'm going to write it here, is motioning to strike the false evidence after you've withdrawn. And there's a duty to rectify false evidence all the way through until the time the appeal has expired. 4B is false testimony by a criminal defendant, and it talks about how complicated that can be. It does discuss the model rules and the minority as the majority of states follow the model rules. And so in that, it's the same exact scenario 1, 2, and 3. First, the lawyer must try to convince the defendant not to testify falsely. Second, if they insist, the lawyer should consider withdrawal if that will solve the problem. Usually it will not. And so third, if all else fails, the lawyer must reveal the situation to the judge, even if that means disclosing the client's confidential information. Under the minority view, which several jurisdictions follow, including New York and California, you handle the problem by allowing criminal defendants to testify in narrative fashion. I'm not going to go into that anymore. So 5, other corruption of an adjudicated proceeding. You have hiding or destroying evidence, bribing a witness, intimidating a juror, buying a judge, or failing to obey the law or court order to disclose information. Letter D, duties of fairness to opposing party and counsel. 1, opponent's access to evidence. 2, falsifying evidence and assisting in perjury. 3, abusing discovery procedures. 4, paying witnesses, so there's no inducements by any lawyer to witnesses. What can be paid is travel, meals, lodging, loss of time, and experts' fees. 5, so D5, securing absence or non-cooperation of witness. 6, there's some weird exceptions to that. And to be honest, I don't understand that section. So maybe reading it out loud will make more sense. A lawyer must not advise or cause a person to secrete himself or to flee the jurisdiction for the purpose of making him unavailable as a witness from Model Rule 3.4a and Restatement Section 116. A lawyer may, however, advise a person not to voluntarily give information to an opponent or other party if the following conditions are met. Romanet 1, the person is a client or a relative, employee, or agent of a client. And Romanet 2, the lawyer reasonably believes that the person's interests will not be harmed by not volunteering the information. I don't even understand that. 6, violating court rules and orders. Okay, so I'm just going to read this because it's funny. A lawyer must not knowingly violate a rule or procedure, rule of evidence, a rule of court, or an order made by the court, but a lawyer may openly refuse to obey such a rule or order for the purpose of making a good faith challenge to the validity of the rule or order. That's in Model Rule 3.4c and Restatement 105. And then there's chicanery at trial, which is number 7 in this section. Types of chicanery. A, referring to admissible evidence. B, asserting personal knowledge of contested facts. C, asserting personal opinions. I mean, this you can do if you're a witness, but that's it. And 8, using threats to gain advantage in a civil case. This is interesting because the model rules say a lawyer can bring or threaten to bring criminal charges against her adversary in order to gain an advantage in a civil case, provided the criminal and civil matters are closely related and that both the civil case and criminal charges are warranted by the law and the facts. However, a lawyer must not threaten to report adversary counsel for a disciplinary violation in order to gain an advantage for her client in a civil case. If the adversary counsel's disciplinary violation is the kind that must be reported, the lawyer should simply report it. She should not use it as a bargaining chip in the civil case. So I just don't understand why it doesn't then say that it's okay in a criminal case to threaten civil proceedings. Anyhow, letter E, duty to preserve impartiality and decorum of tribunal. There's improper influence. Don't offer gifts or anything to the judge. 2, improper ex parte communication. It's defined here. Ex parte communication with a judge, court official, juror, or prospective juror, except when authorized by law or court order. While the proceeding is pending in a tribunal, thou shalt not discuss anything with those people. Okay, no, that was not the definition. The definition, ex parte communication, is a communication that concerns the matter at issue and occurs outside the presence and without the consent of the other parties to the litigation or the representatives. Thanks, Erica. Section 113, comment C is the source of that definition. So you go under judges and court officials, is A, B, jurors and prospective jurors. 1, and under this, there's 1, investigation of prospective jurors. You really shouldn't do that, and that includes friend requesting juror. So 2 is post-trial communication with jurors, which is also wrong, but I suppose the 3 Romanettes here are important. Local law or court order prohibits such communication. The juror has told the lawyer that he does not want to communicate. Or 3, the communication involves misrepresentation, coercion, or harassment. And then there's 3, disruptive conduct. The reason I'm not spending a lot of time on ex parte communications because it kind of makes sense, except for the fact that it's not advance notice when judges, and in the judges and court officials section, it's adequate notice to the adversary. It's to be given when it's allowed under local law and court orders. What is important to know is that a lawyer may never communicate orally on the merits of a matter with a judge or other official before whom the matter is pending without giving adequate notice to the adversary. So that's the key in that section. Trial publicity is letter F, and there's a general rule, the right of reply, and 3, additional constraint on criminal prosecutors. So they just have an additional limitation on extrajudicial comments that have a substantial likelihood of heightening public condemnation of the accused. But dry facts about the case are permitted by both the defense and prosecution. And the rules also apply to associated lawyers. G, trial counsel as witnesses. Reasons to avoid the dual role and conflict of interest. A, B, differing functions. And C, effect on adversary. 2, under the trial counsel as witnesses, the ethical limitations imposed. So the rule, model rule 3.7 will say that this is not permitted when the lawyer would likely be a necessary witness. So breaking that down, A, uncontested matter or mere formality might be all right. B, testimony about legal services rendered in a case. Generally, that's for the purpose of providing the remedy of attorney's fees. And C, substantial hardship on the client. When withdrawing would create a substantial hardship, which tells you what that's not generally. Generally, the justice treats that as a narrow inquiry, and just costs or having a long working relationship is generally not enough. Lastly, D, other lawyers in the firm may be witnesses. And that just is what it is. Now, 3 is the conflict of interest rules also apply, and having to do with the current clients and the former clients. So we read that in another section. So I am in section 7, transactions and communications with persons other than clients. Truthfulness in statements to third persons. 1, must not make false statements of material fact or law, so the lawyer has no duty to inform a third person of relevant facts, but the lawyer must not misrepresent the facts, and explains what types of misrepresentation are. It's like everything, even if it's a part truth but misleading or failing to speak. B, distinguish conventional puffery. So in negotiations, like especially settlement, these are to be regarded ordinarily as mere puffery. 2, failure to disclose material facts, client's crime or fraud. Is that where I ended? I feel like where I ended. No, because then I went to B, communications with persons represented by counsel. 1, when communication forbidden. 2, application to organizations, meaning that a person who supervises, directs, or regularly consults with the organization's lawyer about a matter at hand. 2, a person whose conduct may be imputed to the organization for purposes of criminal or civil liability. Or 3, a person who has authority to obligate the organization concerning the matter, meaning don't speak to those people until you speak to the general counsel. But a former constituent is okay to talk to, but protect attorney-client privilege. Now, communications allowed by the rule. The rule does not prohibit, and I think 1, a lawyer must communicate with a represented person when the communication is authorized by law or court order, and when the communication does not concern the subject of the representation, and represented persons from communicating directly with one another, and a lawyer from interviewing an unrepresented person who may be called as a witness or some other party. So I thought that was kind of important, those exclusions from when communication is forbidden. I'm sorry, from the communication with persons represented by counsel. So C is dealing with unrepresented persons. This is covered in Model Rule 4.3 and Restatement 103. D is respect for rights of third persons. So 1 and 2, heavy-handed tactics is discussed in Model Rule 4.4a, and 2, documents sent to a lawyer by mistake. What it says here is to promptly notify the sender so the sender can take protective measures. Then you move on to subpart 8, different rules of the lawyer, and this is where I ended. A, lawyer as advisor to the client. 1, duty to render candid advice, giving advice beyond the law, and volunteering advice. Really nothing that important there. B, evaluation for use by third persons. Model Rule 2.3 concerns a lawyer who is asked expressly or implied to evaluate the affairs of a client and supply an evaluation for the use of third parties. Note that in each of the foregoing examples that I skipped, the client is the person or entity whose affairs are to be evaluated by the lawyer. The model rule does not apply when a client asks the lawyer to evaluate the affairs of a third party and then to make a report to the client. Now, 1, requirements of the rule. 2, harmful evaluation. 3, confidentiality. 4, lawyer's liability with third person. 5, cases in which opinion is to be widely disseminated. And those include A, securities cases and due diligence required, and B, tax shelter opinions. Then you get to subpart C, evaluation as a negotiator. So I said I was going to read this whole section, but I don't know if I am. I've never been tested on this stuff. Harmful evaluation may be a question on if a lawyer knows or should know that the evaluation will materially harm the client. The lawyer must obtain the client's informed consent before making the evaluation. Confidentiality, except as disclosure is authorized in connection with the report of an evaluation. The ordinary rules of confidentiality apply to the information gained during an evaluation. The client may limit the scope of the evaluation or the sources of information available to the lawyer, but the lawyer should describe any material limits in the report furnished to the third person. The lawyer may have other legal duties to the third person in connection with the report. That depends on the applicable law and is not covered in ABA Rule 2.3. And lawyer's liability to a third person. A lawyer who is hired to evaluate a client's affairs for a third party may be liable to the third person for negligence in rendering the evaluation. So as I read that, I think about when evaluations might apply. It's like in an investigation, for example. Attorneys are often auditors, and this seems like basically auditing function. Cases, auditing or investigating. So cases when an opinion is widely disseminated, when a lawyer agrees to certify facts to a large number of persons who can be expected to rely on the lawyer has a special obligation to be complete, accurate, and candid. So this securities cases comes up here. The special obligation often arises when a lawyer has prepared an opinion letter to be used in disclosure documents for securities investors. The lawyer may be held liable for both misstatements and omissions of material facts. The case here is SEC versus National Student Marketing Corp, NSMC, 1978. Due diligence required. A lawyer is not a guarantor of every fact in the disclosure materials about the company or transaction. However, if the disclosures are inconsistent or the lawyer has a reason to doubt their accuracy, the lawyer has a duty to inquire to determine the correct facts. That comes from ABA Formal Op 335 in 1974. The tax shelter opinions. When a lawyer gives a widely disseminated legal opinion about the tax treatment likely to be afforded an investment, the lawyer must candidly disclose and estimate the degree of risk that the IRS will not allow the tax treatment being sought, even if such disclosure will be contrary to the interests of the client in selling the investment. From ABA Formal Op 346 of 1982. Lawyer as negotiator. Within that section, there's 1, puffing and subjective statements, 2, misapprehension, and that's really that section. So I'll read it. Lawyers must negotiate in both litigation, example, settlement negotiations, and non-litigation contexts, such as real estate transactions, business merger negotiations. Issues of honest and affirmative disclosure often arise in connection with such negotiations. Thus, the rules prohibit a lawyer from making a false statement. The rules prohibit a lawyer from making a false statement of material fact. However, the lawyer is under no duty to do the other side's fact research or volunteer any facts that would undermine the client's position. So material fact is operative there. Huffing and subjective statements, because it is the essence of negotiation that the lawyer attempt to magnify the strength of the client's position. There are some statements that the ABA model rules will allow, even though they may constitute puffing of the client's position. For example, they are not considered attachments of material fact. The key factor to exercise when determining if a statement contains a material fact is whether the opposing party would be reasonable in relying on the statements made. Certain types of subjective statements, such as those relating to the relative merits of the case, estimates of price and value, and a party's intentions as to an acceptable settlement, are not considered statements of material fact in this context. Misapprehension. A lawyer who believes an opponent is underestimating the strength of his client's position has no duty to correct that misapprehension unless the lawyer or the client caused it. Opponent in the Brown versus County of Genesee. Opponent miscalculated amount of lost pay. However, in certain circumstances, the opponent's lack of knowledge of pertinent facts may be so important that disclosure is required. D is going over the lawyer as a third party neutral. E, special responsibilities of a prosecutor. That we'll want to go over. F, advocate in legislative and administrative proceedings. G, organization as a client. That we'll want to go over before getting into the next section, which is safekeeping funds and other property. I might just take a break at this point.